As you can see from the slides, and as Oliver's kindly explained, I'm going to be talking about without prejudice, subject to contract, and without prejudice, safest costs, and what these terms actually mean in light of recent judgments. More so in relation to without prejudice, unfortunately, than the other two, which I'm going to skim through very quickly right at the end. So without prejudice, what does this actually mean? As you're probably already aware, the WP rule will generally prevent statements made in a genuine attempt to settle an existing dispute, whether made orally or in writing, from being put before the court as evidence of admissions made against the interest of the party that made them. This allows parties to a dispute a safe space in which to speak openly and freely when they are seeking to settle litigation. This is obviously important, but it does beg the question when a party is actually involved in a dispute. Is it once court proceedings have been issued? I'm going to come back to this question later when I talk to you about a case involving a principal and agent operating in the food and beverage industry. That's what I was going to say. Not giving away names. First, I'll explain in a bit more detail what the without prejudice rule means. As I've just mentioned, it prevents statements made in a genuine attempt to settle from being put before the court as evidence of an admission. For these purposes, the term admission does not mean a formal admission, but rather a statement made by a party against his own interest. In determining whether a communication is protected by W privilege, you need to focus on the substance rather than the form of the disputed document or conversation. And that means that by simply labelling a document as without prejudice, that doesn't mean to say that we're kind of in the ambit of without prejudice privilege if the substance of the communication is not in the context of a genuine attempt to settle an existing dispute. Also, equally, omitting to label a document WP will not preclude it from benefiting from WP privilege if it is a communication made in the context of a genuine attempt to settle an existing dispute. It follows that although the presence or absence of the WP label will not be determinative, it remains extremely important to get the labelling right. So the importance of the WP rule, as Oliver has already explained for me, and the question of when the parties are involved in a dispute was highlighted in the Taifu case. And as we already know, in this case, the agent claimed that the principal, which is Taifu, was in repudiatory breach of contract when it sent 2 emails giving notice to terminate the agency contract. As Oliver explained, the agency agreement entitled the agent to receive 12 months' notice of termination, but the principal was seeking to terminate on much shorter notice. And of course, the claimant claimed that it accepted the breach, and as Oliver explained, affirming breaches, or not affirming breaches, rather accepting the breach and trying to terminate the contract, and that he was entitled to damages for breach of the contract and also compensation under Regulation 17 of the Commercial Agents Regulations. The principal countered, no, you can't do that. The first of my 2 emails were without prejudice, and therefore the court can't even look at them, must disregard those communications. But the agent argued that they were not protected by the privilege because there was no extant dispute in place between the parties, and therefore communications were not part of a genuine attempt to settle the dispute. The principal issue in this case was therefore whether the 2 emails from the principal to the agent were protected by without prejudice privilege and therefore inadmissible. Luckily for the principal, we won on that issue, and the judge found that the emails sent by the principal formed part of a chain of without prejudice correspondence seeking to resolve the dispute, i.e. the termination of the agency, and therefore the emails were protected by without prejudice privilege and could not be relied upon by the agent. And then we get to that 3rd email that I referred to when the agent accepted the principal's alleged breach of the agency contract, and that was itself then a breach of the agency contract, which was sent on an open basis, and then the judge had to decide whether that was accepted or whether it was affirmed, and unfortunately for the principal, the judge found that it hadn't accepted the breach. We'd continued to carry on with the working relationship, and then that meant that we lost. So this case really does highlight the importance of labelling your documents correctly. So if you're a party involved in the negotiation of a deal that might become litigious, it sounds incredibly dull, but you do need to keep in mind whether your communications are open or whether they're without prejudice, because you might wish to later rely on them in court or not rely on them in court. There are exceptions to the WP rule. I've obviously just explained when the WP rule can be helpful in a dispute, but it's not absolute, and there are many important exceptions to it. Normally where fraud is involved or where there has been blackmail, which is otherwise known as unambiguous impropriety. By way of example, the Court of Appeal was recently asked to consider whether the WP rule applied to a post-mediation communication, which would, in normal terms, be protected by WP privilege because it's in the context of settlement negotiations. However, in this case, 3 months after the conclusion of an unsuccessful mediation, the mediator himself sent an email to the respondent containing a revised settlement offer from the appellant. The offer had been revised upwards on the basis that the appellants had become aware of further wrongdoings by the respondent. The mediator was simply passing on the message really on behalf of the appellants, and he said that the respondent was going to be in very serious trouble and that this could have implications for his partner. The communication was also said that if the offer was not accepted within 48 hours, then the wrongdoings might be made public. But if the respondent accepted the offer, he would avoid the need for committal proceedings. The Court of Appeal found that this was an attempt to blackmail, and it should not therefore fall within the ambit of WP privilege, and it was therefore admissible in evidence. So this case serves as a salient reminder of the types of communication that go well beyond what is reasonable in settlement negotiations. And though it might be tempting if you're ever involved in a legal dispute, you mustn't go around making threats to your opponent. As I said, I promised that I would skim through subject to contract and also without prejudice, safest to costs. Essentially, these terms do what they say what they do on the tin. The use of the phrase subject to contract is usually taken to mean that the parties have not yet reached an agreement and are still in the process of negotiation, or that the agreement the parties have reached is not binding until it's signed. This obviously gives the parties the opportunity to settle all terms and agree all terms before actually finalising an agreement and signing on the dotted line. The importance of the word subject to contract has been illustrated in an employment case in which the High Court held that a letter from an employer setting out a settlement sum and then a subsequent letter from the employee accepting that sum amounted to a binding settlement agreement. Therefore, in your dealings with your suppliers or whomever, you need to remember that if you want negotiations to continue, you must always use the words subject to contract. With respect to without prejudice, safest to costs, if a settlement offer is made on a without prejudice, safest to cost basis, this means if the offer isn't accepted, whilst it can't be referred to during the course of legal proceedings relating to the claim itself, it can be referred to the court on the question of costs. And this is important because if you make an offer to the other side, or in settlement negotiations, becomes litigious and then your offer isn't beaten by your opponent and they're actually awarded less damages or less compensation, then you will want to rely on that communication in support of your argument that you should be entitled to your costs of the proceedings from the point at which the offer expires. But if you don't head your communications in that way, then they might simply be deemed without prejudice, and as we know, they can be inadmissible, even on the question of costs, unless, of course, one of the exceptions applies. That's it.